All right, I think we can go ahead and kick things off. Thank you all so much for joining us for the Alabama Emergency Response Program. The session is going to be about employment law and local resources. Thanks again for joining us. We also want to give a huge thank you to our partner, Bronze Valley. They're in Birmingham, and they have been just instrumental in us casting a wide net across the state and really presenting this program as a whole. So big thanks to them. This webinar is also available for call-in. If you'd like to use audio, you can dial 1-312-626-6799, and the webinar ID is 776-178-240. We really encourage questions during today's webinar. There is a Q&A box at the bottom of the screen. Please type in questions there to send to the host. Any unanswered questions will be sent to the speaker to answer after the webinar. Please don't send your questions anonymously, just so we can make sure to get back to you if there's anything unanswered. And then send emails to prentice@generator.com with any additional questions. But please ask away and take advantage of the expertise today. In terms of technology issues, due to the number of people on the webinar, we won't be able to solve any of these issues in real time, but we will be recording the webinar and we'll share it with all registered emergency response program participants. And we want to give a huge thank you and welcome to our speakers. We have Jonathan Murphy and Aaron Dettling, both of Fortif Law Partners, and we are really looking forward to hearing from them today. So I will turn it over to Jonathan.
All right, thank you, Prentice. Really appreciate everyone taking the time to join us today. Today we're going to be focused on the employment implications of the federal response through the Families First Coronavirus Response Act and the CARES Act. I know that in our interactions with clients, a lot of employers are stuck between a tension of wanting to continue business during this trying time and also wanting to ensure that they're doing right by their employees. So that's put them in difficult positions around whether or not they should be furloughing employees as a result of the unemployment compensation, whether or not they should be encouraging employees to avail themselves of paid leave, or the extent to which that they can continue to work during this time. On the other side of it, employees are often left wondering what types of benefits are out there, what types of new benefits are out there as a result of this, this strange time in which we live. So I'm being joined today by one of my law partners, Aaron Dettling. Aaron has a really strong background in employment law, has practiced for over 20 years, and brings a level of expertise on this issue that I think the participants will find valuable. So the way that this is going to work is Aaron's going to walk us through a number of key questions. He's going to provide an overview of some of this action steps that Congress and the executive branch have taken in order to address employer-employee relationships during this crisis. What we're going to do after that is Aaron and I are going to engage in a bit of a dialogue to sort out some of the nuance around the employment law implications of these acts. We're going to talk about some resources that are available to employees, and then we're going to take questions. So once again, thank you so much for joining us. And with that, I'm going to turn it over to Aaron Dettling.
Hello, everybody. And thank you, Prentice, and thank you, Jonathan. I think, Jonathan, you really did an extraordinary job of setting the stage here for what employers are dealing with as we work our way through this crisis. You know, we're trying to stay open if we can. We're trying to keep people safe. We're trying to not go bankrupt. We're trying not to get sued, trying to fill orders, trying to keep food moving and the things that people need on store shelves. And so The two laws that Congress has passed recently, we'll talk some about the Families First Act and the CARES Act and how these things work together. And they've really brought in a lot of new ingredients to this and a lot of things that we're not accustomed to dealing with. And they did it in really short order. I remember, Jonathan, you and I working over one weekend when Families First was still coming together and trying to piece together this, I don't know, 500, 800 page piece of legislation and figuring this thing out, even as Congress was working on it and changing it by the minute. I mean, we could hardly keep up with the changes that Congress was doing minute by minute. But I think we finally sort of figured out some of the moving pieces here. And so we can hopefully give some actionable information and advice to people and some ideas for how we reconcile all this stuff moving forward. I wanted to maybe, before launching into the new things, Jonathan and I are in Alabama, so things are going to be different in different states, of course. But for us, this paid leave thing is really new. On the federal level, we've never had paid leave before. We were familiar with the Family Medical Leave Act. That, of course, was unpaid unless you could use vacation time or sick time concurrently with it. We had Alabama still has a fairly, I guess you'd say, stingy unemployment compensation allowance. And so we're trying to figure that out. And, you know, beyond that, a lot of the way we did things here in Alabama were fairly laissez-faire. This has brought in a whole new realm of things for us to look at and consider. Just maybe as sort of a historical note, Alabama actually did do one thing with paid leave, I don't know, maybe 25 years ago, relating to military leave. And our courts actually came in and said, no, the way you did that is unconstitutional because you can't just make a private employer pay someone money out of your pocket. The state would have to tax it first and then appropriate it. And I think that's actually correct, incidentally, which is why, and I think Congress understood that, which is why when paid leave came into being with the Families First Act, the flip side of it is the government is going to essentially pay for it, penny for penny, dollar for dollar, and in private employers, public employers too, won't be out any money because of it. So there's a lot of new stuff to cover here. And with that sort of framework, maybe we can just launch in here. So here's what I'm going to cover on Families First paid leave. There are 5, or depending on how you count them, maybe 6 different grounds for paid leave. We're going to talk about that. The different employers who are covered, different employees who are covered by this law, how much time and how much pay you get, which varies depending on which reason for leave the employee is using. There are some exceptions for smaller employers. They are not 100% clear how they're going to work out depending on the specifics of your situation, but there are some exceptions that we'll talk about. And I will want to talk some about how you're going to claim the refundable tax credits at the end of it. And that goes right along with the documentation that we can and can't, and indeed must maintain in order to substantiate the tax credits. So that is sort of our overarching outline. If I can get the next slide, there we go. So starting first with employers, which employers are covered? Virtually all public sector employers are covered. So if you are a city, county, state, or federal government agency, you're covered by this law as an employer. In the private sector, you won't get a clear explanation from me as why it was done this way, but basically speaking, all employers who employ up to 500 employees are covered. 500 and above, larger employers are not covered by it. When I first was reading about this and seeing that provision in there, surely that has to be a typo, but it's true. Under 500 employees, you're covered, and over 500 employees, private sector employers are not covered. I guess the feeling there may be that larger employers like that probably be granting this amount of paid leave anyway. So maybe it wasn't necessary to do it and have a refundable tax credit with it. That's about the most sense I can make out of it. But anyway, so basically that covers which employers are covered. Now, in terms of employees, also it's very broad coverage. Basically, all employees are covered. It's not like if you're accustomed to FMLA and under typical FMLA, the employee has to be employed for a full year and work 1,250 hours. Doesn't apply here. All employees are covered, full-time and part-time. And with one exception, if you're going to ask for the additional 10 weeks for school and daycare closure, which we'll get into in a little extra detail, well, those employees have to be employed for at least 30 days. And so I think that probably won't affect a whole lot of people, a whole lot of situations, but just know that if you have that, I'm going to call it reason number 5. If you have that reason number 5 come up, the employee has to be employed for 30 days for the 10 weeks. They still get 2 weeks. Maybe I'm getting ahead of myself there a little bit, but generally all employees are covered. And then just as a mental note, the law took effect on April 1st of this year, and it runs through December 31 of this year. And so unless Congress changes it, which is altogether possible, that's going to be our window of time. The Labor Department has said that the first 30 days, which we're still in, of course, the month of April, is kind of a grace period in terms of figuring out, because employers need to figure out how to implement this, payroll providers need to figure out how to program it and account for the leave and account for the tax credits and substantiate it all. So from April 1 to April 30, the Labor Department at least has kind of said, we're going to cut you a little slack here. But my clients, at least, we really dug in and we're ready to go on April 1. And that's certainly what I would recommend. And so the other important thing there is, that's fine, Jonathan, leave the slide up. The other thing there is, if you happen to give paid leave in March or before, anytime before April 1, that's fine, but you will not be able to ever claim a refundable tax credit for that, because the refundable tax credit, payroll tax credit, begins April 1, and it doesn't reach backwards into the months before April 1. So I hope that makes sense. So now let's talk really quickly about the grounds for paid leave. And I'm just going to kind of read them off real quick, and I want to come back and elaborate on a few of them. Number 1 is if the employee is subject to a federal, state, or local quarantine order, and that's referring to a legally binding order. Number 2 is if the employee has been advised by a doctor. It doesn't have to be a doctor. Any healthcare provider, it could be a nurse, chiropractor, nurse practitioner, to self-quarantine. We're seeing a fair amount of activity around that one. Number 3 is if the employee is experiencing at least one symptom of COVID-19 and is seeking a medical diagnosis. And then number 4 is going to be if the employee is caring for someone who fits into categories 1 or 2. Number 5, I've already kind of hit on. It's for when a parent needs to care for a son or daughter, child whose school or daycare is closed. That's the one. Number 5 is going to be a little bit different from all the others, remember. And then number 6, similar conditions. So maybe if you could back up, Jonathan, to number 1, it'll help me. Just to elaborate a little bit on the number 1, federal, state, or local quarantine order. This is talking about a legally binding order that is in some way specific to the person. So here in Alabama, and I've had opportunity to look at Mississippi, but no other states. I know this is true in Alabama. There may be specific quarantine orders that the health department is serving on people. I don't know, but in the governor/health officer's most recent order, the one that was kind of a stay-at-home, but not really a stay-at-home, there's a line in there that says anyone who has a confirmed positive virus test result is legally quarantined for 14 days after receipt of the test result. And so that would be an example of something that would qualify under number 1. You know, are health officers out here in the counties issuing other quarantine orders? Maybe. I haven't seen any, but that's quite possible. but that would be the kind of thing that would qualify under number 1. I'm seeing a fair amount of activity around number 2. What typically happens here with number 2 is if you have a worker who may be advanced in years or has been sick, maybe has had chemo in recent years or months, for some reason the doctor feels like that particular person is maybe a little more at risk than the population at large, and maybe more at risk of death or serious disability because of this virus. If their doctor advises them to stay home and self-quarantine, that's going to be covered by number 2. And there's a little bit more detail to that, but that is kind of the nuts and bolts of 2 and the kind of things that it covers. Number 3 is a little bit deceptive in the way the statute was written. The regulations from the Department of Labor have come back behind that and said, it's not symptoms, plural, you only need 1 symptom. And so you may, if you have someone who comes in and requests leave for this, you may want to look back and refresh from the CDC guidance what those are. Off the top of my head, I know fever is 1, dry cough is 1, and there's maybe shortness of breath is the 3rd one that's specific in there. You only need 1 symptom and seeking a medical diagnosis, and that would qualify the employee for some period of leave under number 3, so they can go to the doctor, get tested, whatever they need to do. And then we kind of switch gears here a little bit to the first 3 were for issues that were specific to the person, and then 4 and 5 at least are going to be where your employee needs to care for someone else. So number 4 is if the employee is caring for another person who fits into categories 1 and 2 that we've already talked about. And number 5 is the school and daycare situation. Just maybe a note or 2 on number 5 before we leave that. You know, I guess this is the same everywhere, but here in Alabama, all of our schools are closed. The vast majority of our daycares are closed. And so you're going to have a fair amount of activity around this one. It is limited to a son or daughter. So that's going to be biological or adopted son or daughter. And usually under the age of 18, although if there's an adult child who has a disability, that can count too. The other thing that we're seeing on that is the regulations have come in and said the employee needs to give a little extra added justification if the children are age 14 and above. I guess the feeling there is, hey, if you're 14, you should be on your own. I have a 12-year-old. I'm not quite sure about that, but I guess I have 2 years to figure that out. And then number 6, I'm getting questions about this one already. The statute allows the Secretary of Health and Human Services, in consultation with the Labor Department and I think the IRS, to define similar conditions and circumstances that would qualify for paid leave and then give public notice of that. And those would kind of administratively slot into this number 6. I had occasion to check, not today, but maybe Monday or Tuesday. And as of Monday or Tuesday, there had not been anything specifically defined to go into that number 6, but we still have 9 months. And so we'll need to keep an eye on that to see if anything gets defined into that number 6. Wanted to mention just a little bit more and elaborate on, I'm just going to call it reason 5. It's the school and daycare closure requirement condition. This is the only one that is an expansion of the Family Medical Leave Act. If you are already covered by the Family Medical Leave Act and already familiar with it, congratulations. If you are not familiar with the Family Medical Leave Act, there's probably a little bit of homework that you might want to do, because there are parts of FMLA that are going to apply to this and parts that are not. The biggest difference, of course, is typically FMLA is not paid leave unless the employee is allowed to use like vacation or sick time at the same time as FMLA. They call that concurrent use of leave, running concurrently. This leave is paid for 2 weeks under the first part of the statute, 10 weeks under the FMLA part, for a total of 12. And so this part brings in some other aspects of FMLA that maybe we will talk about as we get farther into this. Yeah, that's fine. So how much time and how much money do we have to pay? The easiest way for me to break this out, the easiest way for me to remember it and think about it is reasons 1, 2, and 3. Remember, those are the reasons that we're talking about, a reason that is specific to the person. The quarantine order, the advised by a doctor to self-quarantine, or the third one would be having a symptom and seeking medical advice about it. So those 3 reasons, the employee can receive up to 80 hours of leave over 2 weeks. I think of it as a full-time employee, it's 80 hours or 2 weeks. For a part-time employee, it's prorated. And the rate of pay is the regular rate. So if they're salary, just whatever the regular salary would be for the day or the week. If they're hourly, just what their regular hourly rate would be. But capped at $511 per day. So you could kind of work that out. I'm not going to try to do math in my head, never mind. But you see what the rule is there. It's regular rate of pay, but it's capped for reasons 1, 2, and 3. And then for reasons 4, 5, and 6, and these are the reasons generally for at least 4 and 5 are reasons where it's not specific to the employee, but it's caring for someone else. It's still 80 hours or 2 weeks, but the rate is capped at the pay rate is capped. 2/3 of the employee's regular rate of pay capped at $200 per day. And so, of course, that's 2 weeks under one part of the statute. And for reason number 5, it can go for an additional 10. And so that's why you're additional 10 weeks. And so that's why you're seeing the higher dollar cap for number 5. There we go. I think this is pretty much the same thing I was saying. Oh, maybe there's one new thing on this. So if you're already covered by FMLA, and so you're accustomed to dealing with the WH 380, 381, 382, you're accustomed to, what you probably use the trailing 12-month period. You're tracking people's FMLA time, so on and so forth. There is an overlap here, so that if someone, for example, has taken traditional FMLA leave, say someone took maternity or paternity FMLA for 12 weeks earlier, no, there haven't been 12 weeks yet, but if they took, say, 4 weeks in January, and now they need another amount of time here, well, within this calendar year, they're limited to 12. So if I've already taken 4 in January and I want to take 12 over here, no, I'm going to be limited to 8 because I've already taken 4. So there is going to be an sort of interplay and overlap between FMLA and the expanded FMLA for coronavirus that comes into play here. That could get squirrely as that unfolds over the next couple of months. When it comes to documentation, I get a lot of questions from clients and employers who want to know, all right, well, if you're going to say you want to be out on leave for 2 weeks because fever or whatever the case may be, well, then I want a doctor's note, and I want to document it. I want a letter from your school or your daycare, whatever the case may be. There's a must and there's a can't involved here, and they're the same thing. The IRS has told us that in order to substantiate the payroll tax credit that we're going to be claiming with our quarterly 941 filings, you're required to collect certain documentation and save that documentation so that if the IRS ever needs to come looking, they can substantiate that the paid leave that you gave was for an actual legally qualifying reason at a legally qualifying time. And what the Labor Department has said, which I just have to say is not in the statute, but the Labor Department has said it, so we have to go with it. The Labor Department has said, in my reading of the regulations, you can't ask for anything more than the IRS requires. So we have to go back to the IRS Q&A, which I'm going to show a link to it at the end of this. There is a whole section of the IRS Q&A that talks about what information you're required to collect and write down and keep that documentation to substantiate the payroll tax credit. And the Labor Department says you're not allowed to ask for anything beyond that. And so it's important for us to get that right. And for my clients, I've created forms for them that kind of walk them through it and really kind of takes it through step by step. And so they ask exactly what they're supposed to ask and nothing more. Write it down, put it in a file, put it in a confidential medical file, by the way. If you remember your Americans with Disabilities Act rules, that goes in your confidential medical file, and put it there. Then there's another hitch here. We've already kind of touched on this for reason number 5, which is that FMLA expansion. You need to use forms WH 380, 381, 382. That's your rights and responsibilities notice, eligibilities notice, and your designation notice. And so you need to, because that 10 weeks for reason number 5 is FMLA, I'm recommending that you use those forms to document the eligibility, rights and responsibilities, and designation of time for that particular type of leave, whether you're covered by FMLA or not. And so again, if you're new to FMLA, there may be a little bit of homework there for you, but thankfully, I've had good luck over the years just using the U.S. Department of Labor forms, WH 380, 381, 382. They pretty much create the forms for you and you can use them. And so again, that's only for reason number 5. All right, let's talk a little bit about the exceptions for smaller employers. And still talking to those employers here for a minute who are kind of new to FMLA, fewer than 50 employees, what can we do here? All right, well, if you're not already covered by FMLA, and I'm being a little bit loose in my testing here, the test for FMLA coverage is not exactly 50 employees. It's 50 within a 75-mile radius, but just give me a little slack here. I'm trying to just kind of hit the high level. But the rule is if you're not already traditionally covered by FMLA under the statutory test under FMLA, then there won't be any lawsuit filed against you for the 10-week leave entitlement for reason number 5. What that means is the Labor Department could still bring an enforcement action against you. There could still be a private right of action for the first 2 weeks that are not covered by the FMLA expansion. Excuse me. Excuse me, but there can't be a private lawsuit against you for the 10-week part.
So Aaron, is this the reason why with your 5 kids, you haven't taken FMLA from the law firm?
I haven't taken leave from the law firm because I love what I do. And it's not possible for me to do both, but I kind of keep one foot there and one foot here. And they have a great mom at home who's a great sport, and we muddle through together. And so I guess that's maybe the better reason why. But I wouldn't sue the law firm anyway. But maybe that's some small consolation for the smaller employers. You know, if all this FMLA stuff is new to you, at least know that for the 10-week part, you know, the trial lawyers are probably not exactly circling like vultures above you, waiting to sue you for that. There's a little relief there. And then the other thing is for employers who are less than 50, and again, this is limited to reason number 5, and that's the daycare and school closure part. The smaller employers here can document and claim an exemption from reason number 5 only, the 10-week part only. And there's a specific procedure and requirements for doing that. I departed from my usual practice here a little bit, and I put the regulation section up there. So if you're interested in there, you can sort of just probably Google Families First Department of Labor regulations, and that'll pull that up. You'll see the regulation, and you can just scroll down to 826.40B, and it'll walk you through exactly what you need to do. May not be a bad idea to get some legal counsel on that if you have any questions, but at least that, hopefully that'll be useful to at least, if you're interested in that, you can drill down and see exactly what it is that you need to do. But again, it's not a complete get out of jail free card. It's very limited only to this reason number 5, the school and daycare part. And then for even smaller employers, if you have less than 25, so under FMLA, we talk about the restoration right, or I think the better word was actually reinstatement right. But under FMLA, we think about, okay, there's a right to take 12 weeks of leave for certain reasons, but then there's also a restoration right that we think of really kind of analytically distinct from the right to take leave, because the right to take leave would kind of not be that useful if your job wasn't there for you when the 12 weeks is over. So we have something called the restoration right or reinstatement right at the end of 12 weeks. And there's rules and regulations all around how that works. But if you're under 25, then that traditional FMLA right is going to be a little more conditioned, and it may or may not apply depending on the facts and circumstances of the case. And it's a little too detailed to get into here, but at least that'll kind of let you know, hey, if you're under 25 and you have someone who takes, again, this is really going to only apply to reason number 5 in the 10-week part, the restoration right may be conditioned. That doesn't apply to the 2-week leave. It only applies to the 12-week leave. If you add the 2 and the 10 together, you get 12. So the restoration right may be somewhat conditional depending on the facts and circumstances. So those are if you're a smaller employer and you're kind of like, man, why do I have to do all this? Well, there may be some leeway and some slack for you there. Take a quick sip of water. You want to jump in with any questions or comments at this point, Jonathan?
No, I think let's continue. And I've got some questions ready for you in a minute.
So a few just kind of high-level questions that I've seen from several clients that I can give some high-level guidance on. Everybody wants to know, well, what if we're a bowling alley and the governor said we can't, or a tattoo parlor, you know? And the governor says, well, we can't have tattoo parlors open. The business has to be closed. Do I still have to pay an employee for 2 weeks off if I'm closed, even if, you know, let's say they tested positive and my business is closed? Well, I'm not paying anybody. How does that work? Well, the statute and the regulations are clear that if your business is closed, or I guess for that matter, if the employee would have been fired for some reason, if they stole from the company or something like that. But if the business is closed, you don't have to pay, and in fact can't pay, paid leave for that time, and then turn around and request a payroll tax credit under Families First. So that is pretty clear. It only counts in times where the employee would otherwise be at work and working. And so if orders dry up and we need to do a furlough, if we need to shut down for a week or kind of do rolling furloughs or something like that, expanded FMLA and paid leave under the Families First law do not apply to those situations. Those are going to be unpaid unless you have a different vehicle, which Jonathan and I are going to bat around here in a few minutes, but you can't use the Families First for that time. Another great question. Okay, say someone has symptoms and seeks medical advice, and they take 2 weeks to get medical advice. And then a month later, they turn around and test positive for the virus, and now they're under a legal quarantine order. Can they take another 2 weeks? And the answer is no. The employee only gets one bite at the apple, 2 weeks. I mean, I guess you could take 1 week for one reason and 1 week for another reason, but there's only 2 weeks of leave available for a particular employee. And so that you only get that one bite at the apple for a total of 2 weeks, or I guess 12 for reason number 5. I've already commented on the similar conditions for reason number 6. The similar conditions have not been defined yet, but again, I think we need to keep a sharp eye out over the next couple of weeks and months because, you know, it's almost certain that we're going to get some kind of additional guidance on what those similar conditions are going to be. And when they are defined, they're going to be just as legally binding on us as a quarantine order. And so we need to pay attention when those do come out. A couple of no double dipping rules. So an employee can't take unemployment compensation and Families First at the same time. So for example, just to use an example like this, if an employee does test positive here in Alabama, that's a legally binding quarantine order. And so the employee takes 2 weeks off and gets paid under Families First. Their full regular rate of pay capped at $511 per week. Well, you can't take unemployment comp at the same time as that. They're still considered employed at that point, and so you can't double dip unemployment compensation and Families First leave. Another kind of double dipping that you can't do is we can use, if you've, as an employer or a business, if you've applied for a PPP loan and you've gotten that PPP money, which by the way, we just saw this morning, apparently the program officially ran out of money this morning, which probably I suspect means it's really ran out of money 4 or 5 days ago and we just figured it out now. But if you have PPP money and you're using it for payroll, you can use that money to pay for the leave, but you can't double dip and say, well, I'm going to use that money, claim a payroll tax credit, and then get the loan forgivable. That's double dipping, which you can't do. So you could use the PPP money to pay for the paid leave, but if you do that, the amount of the loan is not forgivable. I suppose you could not claim the payroll tax credit if you wanted to, but I mean, it wouldn't really be Families First leave at that point. So there's various different ways you could double dip, but you can't do any of them. So one thing I would say that Congress got pretty much right, this is pretty rushed in how they wrote the law, but they got it pretty clear that you can't double dip. At least there's no way that I've been able to discern. Let's see, who pays for this? We've already kind of touched on the payroll tax credits. You probably know if you employ people that there are payroll taxes that are collected and remitted on wages. That is the 6 and some odd % of the employee side Social Security tax, the same percentage employer side Social Security tax. There's the 1% and change of Medicare tax, and then there's the federal unemployment federal unemployment tax. What is the A in the act? I guess FUTA. All those are payroll taxes. The payroll tax credit here only applies to the Social Security and Medicare payroll taxes, but you probably know about that, and probably ADP or Gusto or or maybe QuickBooks Payroll or one of the other payroll providers out there does all of this for you. If they don't, you really should do that, because this is way too much for most people to handle on their own. But the payroll providers get the money from you, and then they write a check to the employee. They remit the money to Treasury and to State Department of Labor, State Department of Revenue. They take all that money and put it where it needs to go, even right down to, like, here in Birmingham, we have an occupational tax. So our payroll provider collects that 1% from us and sends it to the city of Birmingham. And so all that money goes where it is supposed to go. And so they have been scrambling. I know I talked to one client who uses ADP, and, you know, the weekend before all of this went into place, they were still coding and testing and getting all that done. But my sense is that is all being done. And so what you are going to be able to do is the tax credit is 100% dollar for dollar. I was real concerned about some of the original drafts of the legislation, because it was not clear to me that you got 100% dollar for dollar credit. But it is clear under the final law that was passed by Congress that the credit makes employers 100% whole, and employers won't be paying for any part of this out of pocket, at least the required parts, the parts that are required by Families First. And so what you're going to be able to do is actually you can go to the, if you have questions about this, you should go to the IRS Q&A, which I'm going to give the link to. The way it kind of works is, you probably know, you have a quarterly return, which is called the 941. And then, but you also have monthly remittances that you do. And so you're going to be able to actually hold back on a monthly basis any amount that you pay for paid leave under Families First. And so you're never going to actually be out money for that, because, you know, on the day that you are paying that money to your employee, you're going to be holding it back an equal dollar amount from the Internal Revenue Service. So you're going to be, you're never going to be dollars out on this. And so, and that'll be done with no penalties. Let's see, you want to talk about self-employed individuals just for a second. So you can do this as a self-employed individual as well. And the way it's going to work, there's on the IRS Q&A that I've mentioned a couple of times, the last 2 whole pages of that document talk about how to do this as a self-employed individual. So if you're self-employed and if you are unable to work for any of the reasons that we've talked about, you can just claim a payroll tax credit against the self-employment tax that you would otherwise pay. And the IRS has 2 pages of guidance on exactly how you do that. It gets a little bit beyond my ability to explain it here. And then, so of course, also the wages that you pay under this are just not subject to the employer side Social Security tax at all. And so there's a little tax savings there as well. And so I've already mentioned that you're going to hold that back instead of depositing it with the IRS. So super important, if you haven't already put this poster up, you should go to the US Department of Labor website and download this poster and just post it. Stick it up on the wall next to your workers' comp poster. If you have your Family Medical Leave Act poster, minimum wage poster, you know, all those posters, just stick this on the wall next to all those posters. It should have been up on April 1st and needs to stay up till December 31. I mean, if you don't have that up, I mean, that's the Labor Department will ding you on that. So you don't want to get dinged just for not having a poster up. That sort of covers the Families First. I want to see how we're doing on time. That kind of covers the Families First part of it. Congress has done a lot on unemployment insurance over the last couple of weeks. And so most of us labor and employment practitioners out here have learned more about unemployment compensation law in the last 2 weeks than we've ever known in our entire careers. And I've talked to several labor and employment practitioners who have said the same thing. So we very quickly, I would say, get in over our heads on this stuff, but I'll try to give you a high-level overview of what we know about this. So there are several different programs that Congress has put together, and they all have similar names. So that makes it even more fun. So in the CARES Act, we have the Federal Pandemic Unemployment Compensation, FPUC program. That's the one that we're hearing the most about. It's the big $600 per week. And one thing that we're hearing a lot about that is here in Alabama, a lot of workers don't earn that much money. And so if they qualify for even $1 of unemployment compensation under any other state or federal program, they get another $600. And so one of the things that Jonathan had talked about, and we're going to bounce around here a little bit more, is, gee, you know, a lot of employees would, all things being equal, rather stay at home, try to stay healthy, take care of kids, do what they need to do, and get paid $600, which is more than their regular wage. So that's definitely something that we're grappling with. There's PUA, the pandemic, forgive me for looking off screen, I've got my cheating notes over here. The Pandemic Unemployment Assistance, PUA program, that gives an additional 39 weeks of unemployment compensation in addition to other state and federal programs. And it also extended UC to unemployment compensation to stuff like gig workers, self-employed people, independent contractors. And so traditionally, if you were in those categories of kind of gig workers, you did not qualify for unemployment compensation at all. But now with PUA, there's an opportunity. If you are self-employed, you're a gig worker, entrepreneur, you do have an opportunity possibly to, if you're out of work, you have an opportunity to get unemployment compensation if your state is participating in that program. And I would imagine all states will. And then you have the Pandemic Emergency Unemployment Compensation, PEUC, and that just is an additional 13 weeks on top of whatever states do. So my understanding of the way those work is, and I could be wrong, but reading some of the program administration letters over last weekend, you can get your regular state weeks, which in Alabama is typically 14, although it always seems to be changing. Then you can get an extra 13 under PEUC, and then I think you can get another 39 under PUA. So there's a lot of unemployment weeks and a lot of unemployment money that's available under different federal programs. And so really the best source of information on that is going to be your State Department of Labor. They can really fill you in on exactly what your particular state is doing. Every state's going to be a little bit different in that regard. And then the only other thing I just kind of want to throw in on that is the $600, which is really, to me, it feels like maybe the biggest thing for us here in Alabama. That has a use by date on it. It's only good until July 31, 2020. And so a lot of this other stuff goes longer than that. You know, a lot of the stuff we talked about goes through the end of the year, but the $600, unless Congress extends it, we're hoping that they extend the PPP program as well. It's looking like that is going to expire on July 31st. So there's a lot of moving pieces here, a lot of different things that employers and employees need to know about, and hope that was helpful.
Thank you, Aaron. I'm afraid we don't have enough time for you and I to go back and forth with some additional questions. We'll save that time for the audience questions. But I do want to direct everybody's attention to a couple of resources. If you're an employer or an employee and you're wondering how to help your people or how you can get help yourself, whether you need to file for unemployment, you need to use this time that you're at home to upskill or reskill, I want to direct everyone's attention to two websites, and there are plenty others out there. A lot of people are doing great work in this space, but Alabama Works is a great resource if you're an employer, job seeker, student, unemployed person. I would encourage you to use those resources. They provide a really good hub for Alabama-focused employer-employee resources. And second, I want to direct folks' attention to altogetheralabama.org. If you have not visited this site yet, I would encourage you to. It is being relied on as a way to collect information to inform the statewide response to COVID-19. The state's going to be receiving a significant amount of stimulus money from the federal government, and the information collected through this website is going to directly impact the way that they disperse that money. So there are other tools that altogetheralabama.org provides, including if you want to help, it provides avenues for helping. If you as an individual or an employer need help, they can direct you to those resources. So Alabama Works and Altogether Alabama are really great resources for our state that I would encourage all business owners, employers, employees to take advantage of. Some of the resources that Aaron had referred to throughout the presentation are available here on this slide. We'll be making this presentation available on LinkedIn. But with that, I'm going to hand it back over to our generator team to share audience questions.
Thank you so much, Aaron and Jonathan. That was incredibly informative. We don't have too many questions, and it might have been because you covered everything so well. But anyone, please feel free to submit any questions you might have right now for their direct response. You guys might have just done such a good job covering everything. Well, I am not seeing any come through, but I think that is, again, because of all the information covered. We really, really appreciate it and appreciate everybody for tuning into this. I think these are some wonderful resources, and we'll make sure these are available to everyone on our follow-up email at the end of the week that includes the recordings of these webinars as well. If anyone on the call hasn't yet signed up for the office hours, please do so. We're more than happy to meet with you at any point to delve into anything further. And we just really appreciate everyone's time here.
Thank you.
All right. Thank you all. Have a good one.
Thanks a lot, Prentice.
Thanks. Bye-bye.